Today, the whole day was stuck. And today we have got some other work. We need to pronounce the judgment. You take a date sometime next week.
17th of July.
Sometime next week you take a date. Or a week after.
Second week of July, my lord.
Second week of July.
Yes. 18th or 19th, subject to your lordship's convenience.
Yes. Yesterday's matter, sir.
18th of July.
Today it is there, item
Today-
32.
Item 32. The
18th of July.
other bench, regular bench,
Yes.
not this composition.
Yes.
May I have my
Lord, may I live?
to mention a matter, my lord, it's only for listing. This is an appeal from a judgment dated 18th.
No,
May.
no mentioning today. You can't mention this in this division.
Lordship, it was only for listing. It was the returnable date was today. It didn't come in the list only for
Then you
that.
give the papers. Yes.
Great,
My
my
lord,
lord. Great.
one innocuous prayer, my lord. I should not disturb your lordship, my lord. The only urgency is yes, my lord, regarding the transfer of a one polling booth, my lord. And lordship was earlier occasion was pleased to give direction to the respondent number 2 to consider it. My lord, they have considered by their own manner. My lord, in the upcoming election, my lord, only our prayer is, my lord, let the matter be listed so that tomorrow or day
No,
after.
no, you approach the election commission.
If your lordship kind enough.
You approach the election commission by way of a complaint.
No, my lord, we have already, my lord, that was not considered. They have showing the difference.
Then let the matter come. We are deciding the larger issue. So these small issues, we can't be interdicting where to put this chair.
No,
where
my
to
lord,
put the desk.
my lord, it's for the sake of that particular villagers, my lord.
You give the letter, let us see.
Lordship kindly.
Please call the list.
Appellate site, Delhi list, serial number 1.
No, my lord, this is a contempt application
Yes.
under a very peculiar situation. My lords may kindly recollect
Hmm.
that there was an award passed by the tribunal in favor of the NBSTC employees.
Hmm.
Lord, they were not executing the award. We moved the court, and they also filed the challenging the award. Both were heard by your lordship in division bench, and our prayer was allowed. Their prayer was dismissed.
Yes.
The last order, which was passed by division 25th of August 2022, till now, they are not, my lord, taking any steps to execute the award.
Now, what was your prayer in the?
My prayer in the writ petition was, kindly turn to page 75, is the direction given by a single judge, which was upheld by your lordship, giving detailed reasons.
75.
Page 75. Ordinarily, my lord, is quoting from judgment, an award comes into an operation from the time stated in subsection 1 of 17A of the Industrial Disputes Act. That is on the expiry of 30 days from the date of publication in section 17 of the Act. The tribunal has been given power to order that this award shall be applicable from another date. In the fact of that,
WP 4117.
Yes.
What was the prayer in that WP?
the prayers kindly turn to page 54.
To implement.
Yes.
To implement the award. So that is allowed.
That was
And
allowed.
after the judgment, did you issue a notice calling?
Yes,
upon
yes,
the-
yes, yes. Even we have issued a notice for contempt also. Communication was at made page 108 on the 2nd of September 2022. We have communicated the order.
But no,
The
you need,
notice-
please serve the respondent.
Yes, notice be issued. Without court's direction, I can't serve them. But these people are waiting since 2014. When 2014, the award was passed.
And we passed the order in August 2022. Your nice judgment, your.
Whenever my clients, the poor people go to the officer, they say, we are taking steps. We are taking steps.
No, have they filed any appeal to Supreme?
No. That was the initial stand the government is proposing to file.
Hmm.
That proposing to file cannot wait for 1 year.
So Mazmundar appeared.
Yes, with the leave of the court, we shall serve them.
All right. The learned advocate for the appellant, applicant is directed to serve notice on the respondent as well as the learned advocates who appeared for the respondents in the appeal.
You don't get it.
Let the matter be listed. We'll have it on some Friday or something. So it's easier for you. List the matter on 7th July.
I think my lord, your lordship will not seek.
You are not allowing us to sit. You have not allowed us to sit.
Who am I?
From 9:45 we are here.
No, no.
9:30 I came here. 9:30 I am working.
Who am I?
Yes. Milord, with an apologetic hand and mind, Milord, I pray only one thing. Milord, your lordship, Milord, sitting with Justice Bhattacharjee, were kind enough, Milord, to pass an order directing, Milord, the certain owners, Milord, to be evicted, Milord, if they are encroached, Milord, on the pond. Now, Milord, we are not made party. Some of us, Milord, had gone to Supreme Court. Supreme Court said, don't jump out and go to the High Court. I was not
You
a
file
party.
it tomorrow, it will come.
Yes.
Milord, I can tell you.
Certified, without certified copy, Milord, kindly. And
No, you have to seek for leave.
I leave, seeking leave.
Leave grant.
Leave granted, and Milord, kindly direct that matter to be posted tomorrow. Milord, otherwise DM will execute the order. He is a very passionate man, Milord, and very eager to Milord implement. And we have made a prayer to them that we are approaching your lordship. Milord, he said nothing doing. High Court has passed an order. I have to avoid contempt.
But you should serve the writ petitioner.
No, I am not a writ petitioner, Milord.
You are not the writ petitioner, but the direction was issued in a writ petition.
26, I 3 dates. 26 April 2023, your lordship was kind enough to pass the order on 20.
Serve, we will grant you leave.
Serve.
You serve the
Absolutely.
learned advocates who appeared for all the parties in the writ petition.
Deeply obliged, Milord. Deeply obliged. And another, Milord, that Shumoto proceeding was initiated. Deepak Joshi was in the prison for 41 years. It is your lordship, Milord, initiated Shumoto proceedings. That what is the mental health of the prisoner, Milord? This is pending. We are, Milord, the one of the units of the National Law Institute of Delhi, Milord, NLU. Milord, we filed an intervention application to assist your lordship. If your lordship finds that our assistance is cerebral, Milord,
The
kindly
matter
allow.
is running in the monthly list.
No, it is to be listed. It is not listed. My intervening application may kindly be listed with the main matter.
But where is the main matter lying?
Main matter, your lordship had initiated the show motor proceeding. I want to intervene, my lord. Listed, not listed.
So therefore the main matter has to be moved.
Yes, my lord.
But after notice.
The state has in
After notice, you serve notice on the
state, only state.
no
Because High Court has
it's a suo moto proceeding.
show motor proceeding.
You serve notice and please hand over the slip on Monday.
Deeply obliged.
After long days, yesterday I was here in this courtroom. I am talking about
Full day.
I was after long days. Normally earlier I used to stay almost 10:30 to, but after long days I was here.
We'll endeavor to pronounce the judgment now today.
Today. Then we have to wait.
Not required. Your juniors, all your big team is there.
Why should I?
If you allow us to go, we will come back as early as possible.
No, not at all. It is a privilege of mine, my lord, to appear always.
We are trying to see so much of argument, so much of documents, such a big stay applications, annexures, reports, and how many councils argued. We need to consider everything, and so we did our homework yesterday. We are doing our homework from morning. Still going to continue to do it because considering the urgency of the matter.
Correct, absolutely.
Otherwise, we could have reserved judgment and been correct. So this is also time well spent.
Yes.
Of course, a lot of advocates are waiting. Matters couldn't reach, but then some matters need to be given priority. Let us come back. We don't know what time. Let us definitely we'll come back.
appellate side, supplementary list, underdating for judgment, serial number 1 to 3.
We just read some relevant portions and probably in the next 1 or 2 hours, it can be uploaded. The first issue we dealt with was with regard to, of course, the preamble, etc. we said, with regard to the extension of the dates of filing of the nomination or extending the schedule as notified by the State Election Commission dated 9/6/2023. After noting the submissions of all of you and section 43 and submissions of Mr. Bandyopadhyay, section 42, etc. And also taking note of, the question therefore crops up is whether the writ court can entertain a petition after commencement of election process and at an intermediate stage. The 3 honorable judges of the Honorable Supreme Court of India, in the case of Election Commission of India versus Ashok Kumar, 2008 SEC 216, took into consideration the decision of the Constitution Bench in NP Ponnuswamy and another Constitution Bench in Mohinder Singh Gill and summed up the conclusions in paragraph 32 of the said reports. The Honorable Supreme Court in Ashok Kumar held as follows. From the proposition of law laid down in the aforesaid judgment, this court is of the considered view that any action taken or orders passed by authorities vested with the power to conduct election can be made subject matter of judicial review on the ground of mala fide or arbitrary exercise of power of such authority if such an approach does not amount to calling in question an election. However, invocation of judicial remedy has to be postponed till the conclusion of election if the subject matter of challenge amounts to calling in question an election. So, WPA 286 of 2020. In so and so, the writ petitioner seeks for a mandamus to quash and set aside the notification issued on 9th June under 43 of the Act. An attempt made to set aside the notification would amount to calling in question the election. In view of the said aforesaid discussion, this court is not inclined to entertain such a prayer in the writ petition. Before that, we have set down what is the provision of 42, 43, etc. The proviso to 43(1) empowers the Commission to extend the date for completion of any election by issuing a notification for sufficient reasons. The extension of the date for completion of any election may or may not require alteration of date or dates for holding election fixed by the state government under 42. In the event the Commission is of the opinion that there is sufficient and just reasons for which the elections cannot be held on the date fixed in the notification issued by the state government under 42, then the Commission has to take recourse to the provisions laid under subsection 2 of section 43. That is, a reference to be made to the state government in that regard, and if the state government, upon being satisfied with the reasons shown by the Commission, revokes the earlier notification, the Commission shall consequently revoke the notification issued under 43(1). This court is therefore of the considered view that the alteration of the date fixed for election cannot be done by the Commission in exercise of powers under proviso to subsection 1 of section 43. That's our conclusion. If, however, if the Commission for sufficient reason considers to extend the date of completion of any election without interfering with the date fixed for holding the election under 42, such power of extension of various stages of election other than interfering with the date of election can be exercised by the Commission under the said proviso. Therefore, we have held in the light of the said interpretation, mandamus directing to extend the time for filing of nominations cannot be considered. Then the next issue is and we have dealt with you. Please go through it later.
My lord.
And one more thing, we have also taken note of their submission by 1 day, etc. And we have held the discretion to extend the time either under the proviso to section 46(2) lies entirely with the commission, and the commission, being an expert and independent body, is competent to take a decision in that regard. This court therefore leaves such matter to the discretion of the commission. Then the next one is regarding appointment of observers. With regard to that, we took note of the report. Then the stipulation under section 134, section 134 subsection 1 of the 2003 Act, and held thus the statutory provisions clearly provide for nominating an observer by the commission, who shall be an officer of the state government to watch the conduct of the election. The State Election Commission in its report has stated the commission appoints observers from the cadre of senior officers of West Bengal Civil Services and IAS cadre. In our opinion, the exercise to be done by the State Commission, being in accordance with the statutory provision, the court will not be justified in interdicting the same, as senior officers of West Bengal Civil Services as well as officers in the IAS cadre are bound to act in due diligence, bearing the mind and the purpose for which they have been nominated as observers. As held by Hon'ble Supreme Court, the jurisdiction of the High Court under Article 226 to entertain a writ petition challenging election is not completely barred, and the High Court can interfere. The bar under Article 243 OB of the Constitution, the jurisdiction of the High Court is not absolute, and in such cases where there is gross violation of fundamental principles to an election process under the scheme of the Constitution, the High Court would be competent to exercise jurisdiction under Article 226 of the Constitution and pass direction to enable fair elections. We have referred to the decision 1999 for SEC. Thus, for this court to issue direction contrary to the statute, and in particular section 134 of the 2003 Act, would be a step amounting to calling in question an election, which has been specifically barred by the various decisions of the Hon'ble Supreme Court. Corrections. It has been further held, we in Ponnusamy case we referred, it has been further held the mandate of Election Commission is to have free and fair election, maintaining its purity, subject to satisfaction arrived at by the Election Commission on the basis of expert opinion, cannot in a routine manner be interfered by courts. Therefore, we are of the view that appointment of observers from senior officers of West Bengal Civil Services executives, IASs in consonance to 134, and the same would be sufficient safeguard to achieve the object for having free and fair election, maintaining its purity. Therefore, we see no reason to accede to the prayer sought for in the writ petition to appoint a retired judge of this court as observer for the ensuing election. The next issue is with regard to the prayer for filing online nominations. This we have taken note of the earlier decision and of the Supreme Court. Therefore, by applying the ratio decided by the Hon'ble Supreme Court in the aforesaid report, this court is of the considered view that a writ of mandamus cannot be issued to directing the commission to accept nominations in the electronic form. The next issue is with regard deployment of central paramilitary forces. It has been stated by the State Election Commission that meeting on assessment of deployment of forces was taken by the commission on 9/6/23 with the Chief Secretary of the State and the Director General of Police, and an assessment plan by the state will be submitted in due course, which will be reviewed by the commission for taking appropriate decision. The petitioner's contention is that to instill confidence in the electorate, to ensure that fair and transparent election without any violence takes place. Sorry. Before violence takes place can be achieved only by deployment of central paramilitary forces. The petitioner in WPA 287 of 23 would state that prior to the election of Kolkata to the Kolkata Municipal Corporation during 2021 and municipal election conducted in 2020, the state had witnessed large-scale violence which has resulted in various deaths as well. In this regard, the petitioner has relied upon the various press reports which were reported in leading dailies during February 2022, highlighting the violence which has occurred during the said elections. It is pointed out that the State Election Commission during the elections for Kolkata Municipal Corporation declared 1,339 polling centers to be sensitive out of the total polling centers of 4,949. Reference was also made to the judgment of the 5-judge bench of this court in WP number so-and-so, which dealt with the post-poll violence after the assembly election in the state in the year 2021. After taking note of all the above facts and circumstances, the larger bench referred the matter to CBI for investigation wherever allegations are about murder of a person and crime against women, and various directions were issued. The petitioner has also referred to various orders passed by this court from August 2022 till May 2023, where the court had directed the central agencies to investigate into the acts of criminal violence, explosions, bomb blasts, and violence during festival seasons, during religious festivals, and as such, 10 such orders were referred to. The decision of the division bench in WPA 272 of 2021 was also referred to, which concerned the municipal elections, wherein the court observed the election commission is vested with the responsibilities to ensure free and fair, fearless election, to assess the ground situation, take a decision in the manner, etc., etc. In the light of the same, it was observed the election commission, along with the state authorities, is required to be apprised of the ground situation prevailing in Bidhan Nagar. That issue we have referred. Then we have said this court also had an occasion to consider the situation which had arisen during the Hanuman Jayanti festival, and after assigning reasons, directions were issued to requisition the assistance of the paramilitary forces, which order and direction was complied with by the state. It is not in dispute that a preliminary assessment has already been made by the State Election Commission, and several districts have been earmarked as sensitive districts. It has been widely reported in the press that there have been several instances where prospective candidates complained about non-availability of nomination papers, which resulted in violence being precipitated and such other incidents. Considering the fact that the total number of seats for which the election has to be conducted is more than 7,500, and going by the past incidents, wherein on more than 12 occasions, the court had to intervene for directing deployment of central forces or transferring the case to the National Investigation Agency, we are of the view that the State Election Commission should and shall requisition the deployment of central forces to work in tandem with the police force of the state of West Bengal to ensure free and fair elections. It is stated in the report that the assessment plan submitted by the state will be reviewed by the Election Commission to take appropriate decision. The ultimate decision should lie with the State Election Commission, more particularly when it has been the consistent submission of the petitioner that there is inadequacy in police force to be deployed throughout the state so as to cover all polling stations, especially when the number of seats for which elections are to be held are more than 75,000. Therefore, the State Election Commission shall forthwith requisition of deployment of the central forces. At the first instance, for all the areas and districts which, in the opinion of the State Election Commission, have been declared as sensitive. Thereafter, the State Election Commission shall review the assessment plan submitted by the state, and wherever there is inadequacy of state police force in all such areas, the State Election Commission shall requisition the deployment of paramilitary forces. This requisition shall be done forthwith by the State Election Commission, and on receipt of the same, the appropriate authority of the central government shall deploy the required strength without loss of time. Considering the facts and circumstances, we are of the view that the charges towards such deployment shall be borne by the central government and no part of it shall be charged to the state of West
Grateful,
Bengal.
Your Lordship, grateful.
Then we have done,
Not only
Uh,
one thing
then-
with regard to this, Your Lordship has recorded municipal election.
we have not completed. We have not completed reading the judgment, or we'll say disposed of. If you want, you.
No,
go
not
through
that. I is just pointing a not correction. I'll point,
it.
I'm,
You wait for some time. Can you not wait?
sorry, I'm sorry, Lord, I'm taking a note.
We have been doing this from 9:30 in the morning.
I'm sorry. I'll.
There's a
point it out.
decorum to be observed,
I'm
Mr.
extremely
Counsel.
sorry. I'm extremely sorry.
Next issue is with regard to installation of CCTV cameras. After taking note of the report, saying that it is not feasible, we have said, therefore, a workable solution has to be worked out so that no polling station escape from surveillance of the State Election Commission. Therefore, we direct the State Election Commission to install CCTV cameras in all polling stations and only such of those polling stations where it is where it is technically not feasible to install CCTV cameras. In those stations alone, the entire process commencing from the filing of nomination papers till declaration of the results have to be videographed. In case the State Election Commission is to requisition CCTV facility installed by the police department, then the police department should share the link with the Election Commission so that the video footage which have been recorded and live streamed can be viewed by the State Election Commission and such recording be saved in the data files for future reference. Then ultimately we said, while the steps taken by the Commission is appreciated, it should be ensured that the video footage have to be preserved and shall remain in the custody of the Commission. And in the event of any eventuality, the footage has to be viewed by any authority shall be made available to the appropriate authority in the event of such requirement. Simultaneous counting we have approved. Then regarding filing of nominations before the district magistrate, we held that that prayer is contrary to section 44, 46, 1, etc. can't be exceeded. Then the next one is regarding deployment of these contractual workers. We referred to all the submissions of the interveners of Mr. Sanyal, etc. And then referred to the handbook of for the returning officers published by the state and the 94 Act, 2003 Act. In view of the provisions laid down under the 1994 Act, read with the 2003 Act, the appointment of presenting officers and polling officers, this court is of the considered view, the persons who do not suffer any disqualification for appointment as presiding officers and polling officers, as specifically provided under 6 of the 94 Act, read with section 28(1), can be appointed as presiding officers and polling officers. Then we said this court directs the Commission to keep in mind the provisions laid down under the 1994 and 2003 Act, for as well as the stand taken by the Commission as indicated in its report filed in court. Then, with regard to deployment of contractual employees and NCC boys, the handbook states that they will be deployed as a last resort. However, the handbook further states that the fourth polling officer may be drafted from Group D officers. Thus, it goes without saying that if contractual employees and NCC boys are to be deployed, they are to be deployed to undertake a work lower than the work assigned to the fourth polling officer and not assigned any duties above the fourth polling officer. By then, Mr. Sanyal referred to section 9, etc. Section 7. And we have referred to that State Bank of India case, etc. With regard to engagement of civic volunteers in election work, it would be relevant to take note of the circular issued in memo number so-and-so, the IGP dated 24/3/2023, wherein the duties that may be entrusted to civic volunteers has been specifically laid down in the circular. Then we have quoted the relevant portion. In view of the circular being issued by the competent authority of the West Bengal Police Directorate, this court directs the commission not to entrust to a civic volunteer any duties beyond the said circular in a circle, full stop. In case, in case the commission decides to engage civil volunteers for discharging any of the duties with regard to conduct of the Panchayat election. The next aspect of the intervener was this protection of the polling officers. Then we refer to this Rajkumar Ray, teacher Uttar Dinajpur, etc. Then the association represented by the secretary, how the inadequacy, etc. Then about how many instances of death which are reported in general election 2019, assembly election 2021, 15,000 cases of post-poll violence after the West Bengal municipal election, etc. It is stated that the association is a registered body under the West Bengal Societies Registration Act, and it's a united forum of teachers and teaching staff. And they have come forward conveying their grievances and demanding adequate security, etc. Therefore, we are the view, direction will be at, we have directed requisition of paramilitary force, and on an appraisal being done respect of other areas where violence is anticipated, directions have been issued to the commission to requisition the required paramilitary forces and coupled to the direction to provide the same at the cost of the central government. Therefore, we are the view that said direction will adequately protect the interests of the polling officers and polling personnel. It goes without saying that the State Election Commission should undertake all steps to ensure that safety and security of the polling officers and polling personnel. All preventive measures shall be taken by the commission, and standard operative procedure can be devised to be implemented in all polling stations throughout the state. In the event if in a particular police station central force has not been deployed, then it shall be the responsibility of the state police to ensure the safety and security of the polling officers and polling persons at such polling station. Therefore, there will be a direction to the commission to ensure the safety and security of the lives of the polling personnel and polling officers. And the event of any complaint being brought to the notice of the commission, swift action should be taken, and the persons who are indulging in violence should be severely dealt with. This direction be complied with in its letter and spirit without giving any room for laxity. With the above directions, the writ petitions are disposed of. Yes, what is the mistake?
I'm sorry, my lord, your lordships have recorded the last municipal election of 2020. It is February 2022. I could not find out while reading your lordships, reading the judgment.
That is that municipal election.
Municipal election, your lordship has recorded.
In one place, we have said 2022. In another place, you
Yes.
say it is
Where your lordship was not dealt with that CRPF, not that portion, Lord, I was trying to point. But I'm sorry, Lord, I should have waited. I was taking a note and I could not, Lord. I'm very sorry.
No.
I'm very sorry. After Kolkata Municipal Corporation, then your lordship has recorded municipal. After Bidhan Nagar recording that, then that came. Perhaps it has gone down as 2020, perhaps. Taito naki?
Municipal election conducted in 2020.
Yes,
It
yes,
should
that
be
time.
2020.
2020. Actual date is 27th February 2020.
Well, just to clear myself, only one place, Lord, that your lordships have directed that already the booths or places which have been identified as
Districts have been identified
as a
and
sensitive.
notified by the commission, which has been widely reported. To my recollection, our recollection, 7 districts
Yes.
are declared as sensitive.
Anyway, that's that there, this central
Provide
forces.
all the support to the commission, sir.
Only, yes, only the central forces would be deployed. So, but the rest is concerned, they will make an assessment then. Well, we are ready with the supports.
Yes, that is what
We
is.
didn't,
Yes, I'm
yesterday, I thought it that your lordships would be dealt with this central forces matters, because your lordships in earlier judgment, earlier on the other day, your lordships have said that it will be decided by the central commission, that therefore I have not addressed the issue. I have not addressed this. We have requisition.
Upload the judgment. Any party who's aggrieved
No,
can,
Lord, one,
their avenues are.
Lord, one
no, I am not on that. I am not agreed. I am
Uh,
not saying I am agreed. I am submitting, Milord, that.
This is what can be done
No,
in
no.
the shortest possible time.
Very nice. Milord. I am not on
one
that.
indulgence only, Lord, my Lord has
Milord,
granted. sufficient purpose.
Therefore, I did
Let
not
them continue
address
till the
this
counting is over.
ভাই একটু ভাই বলতে তুই তো সবসময় তোরাই বলবি
বলে দিন, স্যার বলুন।
তোদের 10 জন অ্যাপিয়ার করছে তোরাই বলবি
স্যার বলুন।
I didn't address the issue since your lordships have passed an order on 9th. That is regarding the central forces, the election commission will take a
That
decision.
was a prime facie observation
No,
for them to respond.
Anyway, that's my misunderstanding because
No, it is the commission which has.
no, I am not on that. Milord. My misunderstanding in view of the clause 10 of that order that a prima facie in other places prima facie words have not been. To inform to your lordships, Milord, I wanted to I would have addressed this issue. 15 battalion requisitions have been made by the state from different states.
This was not said.
We have already requisitioned it. 15 battalions, one battalion.
Now they are
means-
getting
it
free
is
of cost from the center. Now they are getting, Lord, one thing.
No,
only.
you are not required to give
Lord,
advice.
your lordship has seen, your
No, you
lordship,
will not required to advise.
your lordship has seen
Election
death
has
of
been, election
500
has,
persons post-poll violence. Lord, let the CRPF continue till the counting because majority of, Lord, that will.
Commission will, they'll requisition, sir. When they have to be sent back, they will decide, sir. Don't worry.
we will be disturbing your lordships in another big constitutional questions matter coming up.
But they are
Come,
grateful.
we'll come.
And that will, your lordship will be happy to,
Yes.
regarding the legal constitution, it will be having a national impact.
Please, we'll decide.
The total number of seats in the panchayat is 7,500.
75,000. No,
No. No, at one place, perhaps that was the municipal. Kolkata municipality. Yes. One WhatsApp number maybe where we can complain. Kindly, that
it is there with the commission. It is there with the commission.
So there, if the once it is double, at least they cannot deny that we are not informed. So I can agree.
We passed it.
But we are grateful to you.
Grateful to you.
You,
Milord, for our
want the requisition without loss of time, you provide.
for
During the polls or also during any time.
Right from now, right from now.
my lord, for
Till the completion of the process,
Lord,
that will
kind
include
for-
count.
getting my to me cleared by myself, clearing, don't take it that
Lord,
I am thinking about other avenues.
Lord, I am very sorry, my Lord,
Get
kindly.
this idea from your lordship's mind.
Lord, I am very sorry. I am very sorry. I traveled your lordship 3 days.
Numbers may be circulated among the.
That they will devise, sir. But nobody is there from the commission.
No. Yes, he is there.
No, she is not an employee of the commission.
No,
She's a lawyer.
Lawyer.
There are 5 people, one
They were
bearded.
not aware.
If
They were
it
not
is,
aware.
yes. Both they were here. Both days they were here.
Now everyone is hearing.
They are hearing online, subject to correction.
Oh, they are hearing online.
Lord, we can,
Uh,
Lord, we
That's
can expect that there will.
That's the reason I said.
We will try to upload the order as early as possible.
Unless there is any number notified, the complaint number, the situation may arise that nobody has complained.
Yes.
Only one thing, commission will give a number.
They will devise some method.
Yes. Yes.
You convey it to the
And
commission.
CRPF till completion.
That's the reason exactly.
Say they want some redressal mechanism.
Yes.
Suppose now you are booking for a gas cylinder. Are you going to
The
the,
problem is the.
are you going to the dealer?
The problem is this.
You get a
Milord,
OTP.
The problem is this.
So therefore.
Nobody wants
some-
to, no, the who are appearing, they do not know what are the mechanism is. If a
there's
complaint is made, first one has to make before the returning officer. Or the police. Yes, that's the law. Yes, that is the law. That is the
But
law. Mechanism is
till
fixed by the statute.
Yes.
Yes,
Yeah, man.
that has been
Mechanism
dealt
is
with.
fixed by the statute.
Lord, extremely grateful to your lordship, Lord, extremely grateful.